Sorry about that, everyone.
There we are.
All right, Joseph, I'm making you host. You have the waiting room to let people in. And I am out of here. It's recording too now, so.
What'd you say?
It's already recording, so you're good on that.
Awesome. Thank you.
Bye.
Hello, everyone.
Good afternoon.
Let me switch out. Right. How is everyone today?
Good enough. How are you?
Very good. Thank you.
Good.
All right. So today we are discussing, what day of the week is this? This is the listing contract. Or the listing, I should say the topic is listings. So quick question, or seller forms, I should say. Any specific questions you have for seller forms or anything that you want to go over? Because if not, we'll walk through it and we'll use this as an opportunity to just share what's been going on. Of course, my form to bring up and share screen is a little delayed. I'll get that here to you shortly.
Hey, Joseph.
Yes.
I was just thinking if there's some things that you see a lot, maybe just point those out.
Yeah. Yeah, that's what we'll do. So let me start sharing the screen and I'll pull this up here. All right, so I'll pull up form 220, which is our listing agreement. While I'm doing that, one thing that did come up this week that I want to remind everyone while we're talking about this is the offer rejection form. It is required, South Carolina law does require that all offers that are given, if your seller does actually reject them or they're not going to counter, that you do need to present them with an offer rejection form. And the reason for that is obviously so they know that it's been presented. Now, there are two forms that are involved in that. One is the multiple offer form, which basically says we're rejecting and calling or letting you know there are multiple offers. That is actually signed by the seller. And then the other form is the one that is just the offer rejection form that is only signed by you as the agent. That second one is the one that is required in any situation where your seller, if they are not going to continue negotiating, you actually have to sign that and send it to the buyer's agent. The reason I bring that up is we've had a lot of lately, a lot of people lately who have, sorry, it's asking me to let everyone in, who have had that request from a buyer's agent and thought that that was not typical, and it is. So we just want to make sure that you are remembering to send that form should your sellers ever get to a point where they stop negotiating. Okay. All right, so give me a thumbs up if what you see in front of you is the listing agreement, Form 220, and the shared screen. Okay, good. All right, so I'm going to walk through this, and this is going to give us an opportunity to talk about some things that we're seeing and how to handle them. If you're just joining in, one of the things that I did mention that is has come up lately is the multiple, or not multiple offer situation, but in a situation, if you are representing a seller and your seller is going to stop negotiating, meaning they're not going to respond to a counter or they were just not coming to a meeting of the minds, the offer rejection form is a required form. So you just want to make sure that you keep that in mind. There are two types of them. Let me see if I can find them really quickly. I'll come back to that. We'll talk about those when we get through this one. Make note of it. Okay, so listing agreement. basically, just going to walk through this, some things to keep in mind. The first part of the listing agreement is pretty standard, all the property information. This is where you would put in here what all is included, if there's any fixtures or appurtenances, any additional personal property that would be on here. My advice in this situation is what I tell sellers is, even if it looks good, if it's something they're intending on taking, they should get it out prior to listing the property. Light fixtures, window treatments, that sort of thing, if they're going to do so. We had actually an incident a couple of years ago where the sellers had photography taken on the house, and one of the things they were changing out were the light fixtures in the kitchen. So buyer showed the house had the actual light fixtures that were staying. However, when they got their appraisal, the buyer compared the pictures of the appraisal to the pictures of the MLS and realized they had been changed and tried to fight for it. Luckily, we had some pictures taken during an open house prior to them seeing it and were able to prove it. My point is that it can just try to avoid any sort of situation like that where there may be some sort of conflict. Now, in this, the consent for designated dual agency as well as designated agency, just a clarification, if it's on your team, if you're on a team, or if it's your own listing where you're going to represent a buyer, or you're already representing a buyer, I should say, and not using transaction brokerage for the buyer, it would be a dual agency situation. It would be dual agency if I were to be the listing agent on one. However, from a seller standpoint, the only times it would be a dual agency for you is if it were a buyer you already have or a buyer from your team. Everything else, if you did have, would be designated agency if it were with any other Keller Williams agent in Charleston. As far as when I say Keller Williams agent in Charleston, that are in one of the Charleston offices. So that doesn't pertain if you have an agent that was licensed in Columbia, Myrtle Beach, Beaufort, anything like that happened to come up here with a buyer, that would not be dual or designated. But it would be if it were under the same brokerage where I am the broker in charge. Terms of the listing agreement, pretty simple. This is where you're going to put your price in. It's also where you're going to put your total commission in here. This is a change from before, but this total commission is where you're going to put it in here. So if you've listed a property and your total commission is 6%, you'd put the 6% here. We'll get into the offering on the co-op side and what that looks like here in a second, because that's now addressed on page 2. This is also where it stipulates where the brokerage fee is earned. This is a good, as I say with any contract, it's actually a good template for a script. So when I'm going through the contract with my seller in the situation, I can simply go through and say, here's the price, commission. However, understand that the brokerage fee is earned, due, and payable when agreement to purchase, option, exchange, lease, trade is signed by the owner. However, if owner shall fail or refuse to sell the described property for the price and terms, they still could be held liable. However, Mr. and Mrs. Seller, we're in this business together, and the point is what this is saying is that I don't get paid unless this closes. Technically, it'll say it was earned, but I'm paid on a contingency. Okay. Now, there is a protection period that's in this, which is this paragraph right here. It basically says if this property does sell within a certain number of days, and normally I put 30 days in here, of the expiration or termination, then I still would be due a commission. Now, that would be exempt if you enter into a listing agreement with someone else. So if I have Jane's house listed, we expire or we terminate, I'd be protected for 30 days unless Jane went and listed her house with another agent, with another broker. Now, the reason I specified broker on this is because if they do list with another agent within Keller Williams, that would be something where we technically would have to work out what that would mean for them, because that would not exempt them from it if it were listed by the same brokerage. Doesn't happen often, but when we have had it happen, typically we get that worked out one way or the other. And then the last part of paragraph 2, which is for the purpose of this agreement, a sale shall be defined as the transfer of legal, equitable title or beneficial interest of the subject property, whether for money or in exchange for other property. The reason I point this out is whether for money or in exchange for other property. So there has to be an exchange of money. The reason I bring that up is we did just recently have a situation where buyer came down, closed on a property, They signed everything. They got in their car and they went back up north to meet the movers. Their cash had not been transferred yet. It was a cash deal, and then the buyer went dark. Completely fell off the radar, claimed health issues, was not going to transfer the money. Seller said, listen, we've all signed, we're done. Attorney said yes, and they are in default in the contract, but they technically have not, this property is not closed because there was no final transfer of money. So just, that the reason I bring that up is that question comes up a bit, is if it doesn't fund, is it closed? And in this case, the law firm was Weeks. Their interpretation is no, it is not closed if funding has not gone to the seller. So just keep that in mind. It doesn't happen often. All right, compensation to other brokers. This is the fun part. So this is where you get to offer out the co-op a incentive to come sell your house. We do offer to buyer's agency, transaction brokerages, but not sub-agency. Quite honestly, sub-agency's irrelevant on here, but we don't offer it to sub-agency because we basically, if they don't have an agency relationship, they're automatically in a transaction brokerage relationship or non-agency. I recommend, again, I'm not going to get, I personally am not going to be in the business of dictating how you run your business. I recommend that you offer a buyer agent the same that you would a transaction broker. I don't think there's any reason to discourage one or the other to come and show your property, because there's really no difference in exposure or liability to you as the listing agent. Now,
Is there a minimum amount like
um,
South Carolina requires you to put in there for buyer agency?
no, there is not. This can be zero. South Carolina especially would not require a number on here. They wouldn't require compensation. A couple of things the question comes up on this one is, is offering out, my personal opinion is if you're going to discount your commission, you need to discount it on your side first and not the buyer's agent side. Again, it's your business though. I don't want you to, I don't want to dictate how you do your business. One thing that you do need to keep in mind is the buyer's agency agreement does have an option on there that says that the buyer will make up the difference if the buyer's agent is not offered 3% or X%. So what we're seeing happen a lot more than usual lately, and this is kind of throwing a lot of people off because they're getting their feelings hurt and there's nothing wrong with this, is we're having buyer's agents who are approaching a listing that is offering 2.5% and saying, hey, you're only offering 2.5%. Is it possible for your seller to actually offer 3%? Because if not, that difference is going to have to come out of my buyer's pocket. And that will just that means it'll cost my buyer more to purchase this home. Now, there's a couple different schools of thought on this. Number one is, is that a good way to run your buyer's agency agreement? Well, maybe, maybe not. It really doesn't matter. They did. So if you do have an agent that comes to you and says, hey, I have a buyer's agency agreement that is for 3%, you're offering out 2.5%. Are you willing to change that so it doesn't cost my buyer more? That's not a terrible thing for them to ask. And it is a disclosure situation. So they then now know that their buyer is going to, or you now know that their buyer is going to have to pay a little bit more money for them to get the house, because that'll come out of their pocket. So I tell you that just to let you know, because when you get that call, inevitably what happens is you'll call me and say, this person's saying they're not going to sell the house if I don't offer them 3%. That's not what they're saying. Well, it's not what they should be saying. What they're saying is it just could cost their buyer more to purchase this house than it would one that is offering 3%. Make sense? I'll do a quick stop sharing to make sure I not missing anything on here. Jill Craft.
Can you repeat that in summary? I didn't get all of it. I didn't understand all of it.
Yeah, so if you
I understand the issue, but how to deal with it.
Yeah, so if you're a listing agent and you're only offering out 2.5%, which by the way is just, just keep in mind that's going to, a lot of people are offering out 3%. So if you're offering out 2.5%, if a buyer's agent has a buyer with a buyer's agency agreement, and in that buyer's agency agreement, there are 4 different ways they get compensated. And typically the one that we all choose is the one that says I'll get paid from the transaction, whatever the transaction may offer. Well, there's another one that says I'll get paid from the transaction, but in the event I don't get paid at least 3% or whatever they fill in the blank, then you, Mr. Buyer, will be responsible for the difference. So if Sean's representing a buyer, if Sean's representing a listing and they're only offering out 2.5%, and I'm representing a buyer and I've signed a buyer's agency agreement that says I'll get at least 3, if Sean is not willing to offer more than that 2.5%, then I just need to let Sean know, or I'm going to call and ask her if she's willing to offer more. And if not, just let her know, just so you know that purchasing this property will cost my buyer more money because they're going to be paying the difference. So it's a disclosure issue. Again, this is not to say I agree or disagree with whether or not someone should handle their buyer agency agreements that way. There's mixed feelings in that, the majority of which offer, they have their buyer's agency agreement that say, hey, I'll just get paid whatever I get paid. That's starting to change a little bit because there is a compression on commissions, and that compression on commissions is causing people to maybe dig their heels in a little bit on the buyer side. So just something to keep in mind. And by the way, something to tell it's also a good script when you're talking to your sellers about why you don't discount your commission. Because if you discount the commission and if you take it from the buyer side as well, there is a risk that some buyers will have to spend more money on their house to cover the difference in the price, or cover the difference in the commission.
Joseph, not to put you on the spot, but how would you handle that if there was a 2.5%? Would you approach the agent or not?
Personally, I would not.
Okay.
That is not a statement to say if you do, it's bad, though.
Right.
I just don't think it's, but that's just personally where we are. And I'm not saying that that's something that would be changed as commissions go.
It's just I appreciate your sharing it.
Yeah, absolutely. And there is also something to be said, by the way, in that situation, you don't have to hold your buyer to that. So there is something to be said. We're getting a little off track because get to the buyer side, but it's just something to keep in mind. There's something to be said to having that in your buyer agency agreement to use as negotiation for your commission when you do submit an offer. And if the listing agent or the seller says, no, I'm not going to change it, then you can just decide not to hold your buyer to it. But at least you tried then to get higher co-op commission. All right, so let's jump back into the contract. So earnest money, again, this is, I love earnest money right now. Earnest money basically just defaults, or this paragraph basically says, hey, when a buyer puts an offer in on your house, they're going to authorize an escrow agent to hold earnest money. There's no required amount of earnest money. Earnest money itself is not required. However, what this is it's basically a prospective buyer that is saying, here's the money that's promising I'm going to perform on the contract. The reason we have this paragraph in here, Mr. Seller, is basically for this bold paragraph right here that says, even if the buyer clearly defaults on this situation, we cannot have the earnest money just released without some sort of disbursement agreement. And you just want to tell sellers that because a couple things are happening right now. Buyers are putting in enough earnest money where they don't care and they'll just walk because it's only $500 or $1,000 and they're spending a lot of money on the house. But what we get into is what you don't want to get into is where a seller thinks that just because it's a blatant default on the contract that they automatically get their money. And basically that's what that paragraph is saying, is that is not in fact the case. Paragraph 5 just simply says that you will have exclusive right to display for sale sign under contract, sale pending, or other similar signs on the property. And that they, remove any other signs, meaning I'm going to be the only sign that's there because it is an exclusive right to sell listing agreement. This does, well, we'll come back to that. We're going to talk about the coming soon here. It's addressed specifically. Then this goes through the duties, right? What is the broker's duty? Basically on here, and I'll just read through it quickly because, by the way, this is also a good script when you're talking to someone of what you're going to do. Sorry, this keeps popping up. I want to make sure I'm not missing anybody who's in the waiting room. All right, so I agree to employ the best efforts of my brokerage and my agents and staff to secure a contract of sale for the described property. include direct efforts of the broker's organization to bring about the sale, advertising the described property as broker deems advisable, and those advertising medias of merit customarily used in the area. Furnish such additional information as is necessary to cooperating real estate brokers and assisting the brokers in effecting a sale of the property. By the way, this is an important thing to note here is by furnishing such additional information as necessary to cooperating real estate brokers. This is part of the duty that you've signed up for. So if you are busy, I understand that, but understand if brokers are reaching out to you for, I should say, pertinent information is part of your job to follow up with them. That's what you've agreed to do. So just keep that in mind. Owner understands the broker makes no representation or guarantee as to the sale of their property. Upon the termination or completion of this agreement, broker shall keep confidential all information received during the course of this agreement. So again, this is kind of what I'm here to do. This is stating what I'm going to do for you from a legal standpoint. Paragraph 7 says, what are my limits on this? And basically my limits is anything outside of the advertising and marketing of your property. You basically are going to be paying an attorney the fees for this. I am not an attorney though. This is basically saying that I am not an inspector. I can't translate contracts and all of this. There is part of this paragraph that does try to, well, it's right here basically. This is owner will indemnify and hold harmless and pay attorney's fees for broker for breach of contract. So basically what this says is if you breach the contract, owner, and I have to get involved in this, that I won't be held liable and you'll cover my brokerage fees. We have had a handful of sellers that are, or excuse me, my attorney's fees. We have had a handful of sellers that are pushing back on this because they don't want to be held responsible for other people's fees and that sort of thing. If that happens, double check with me. It's also not something that I think is worth pushing back on. If your seller wants this one struck, that's fine. Because if somebody wants to sue, somebody's going to sue. So whether or not this is in here isn't going to matter anyway. But basically what this is saying is that I'm here to help secure a contract on your home. If you were to get a contract and default on it, you could be held liable for my cost and exposure as well, which is not a bad thing for the seller to know. Now, again, is this going to be part of your listing presentation initially? Probably not. But as you go through the document, it's important you know that. And then paragraph 8 basically summarizes everything they're going to do. Make sure you have reliable information. This defaults to any inquiries coming in that you're going to immediately put them to me. You're going to permit inspections. We're going to offer the properties for sale to prospective buyers without any sort of discrimination. This does give you the option to recoup some marketing fees, but it's basically saying that you'll allow me to spend up to X amount and reimburse me. And then anything above that, I'd have to get permission. Most people at this point are putting 0 in there. They're getting paid on a contingency, so they're taking the risk. There are a couple of people that will put a $1,000 fee in here that will cover their marketing, which basically only hold their client to it should they try to cancel the contract early. Allows the closing attorney to pay the commissions. That you have permission to to supply the pertinent information after the sale for comparable purposes in the MLS. They're going to let you take photographs. Yes.
Joseph, where does it say about marketing in that? Because I always put 0 because I thought it was like I don't want to incur any expenses on the seller needs to pay for their own repairs or whatever they're going to do. So how did you?
Well, I mean, it's not, it doesn't say marketing, so you're correct on that. But people will use that in there. So technically for this one, you're right. This would be for repair, inspection, and utilities. They would put the marketing one later in the contract.
Okay.
Sorry, in the stipulation ones. This would be more designed for situations like if you had bank-owned properties or that sort of thing. If you do get into those situations, I would highly recommend that we talk first about how that should be set up and that sort of thing. It's because you don't want to be taking on any more liability than you have to. All right. To convey marketable title for the property basically means that the property can be sold free of any liens. Again, more authorization for the attorney, that they're going to allow the attorney to disclose the information, give information to the buyer, authorize the broker in response to inquiries from buyers and co-ops to divulge the existence of offers on the property. You obviously want to be able to tell them that. You don't have to tell them the details of it. And then furnish the broker with written instructions regarding any confidentiality of information upon terminating or completing this agreement. So if they did terminate the agreement, if they wanted any information then made confidential, mainly stuff in the MLS, most personal stuff would be protected in the agency agreement anyway. Okay. All right, so paragraph 9, I'm not going to go through this line by line. Here's how to describe this. Paragraph 9 is, so Mr. and Mrs. Seller, I'm going to send you, after we fill this out, what's called a property condition disclosure statement. And what this paragraph here says is when you fill that statement out, you're going to fill it out to the best of your knowledge. It's going to ask you basically a blanket question that says, are there any issues with this current area of your home? And your answer is going to be one of 3. Yes, there is. No, there is not. Or I do not have any representation of that. So when you fill that out, this paragraph is saying that you're going to fill that out honestly. You're going to go through and you truly, if you do not know, you will put no representation. You won't put no if you don't know. And if you do know, then you'll obviously put that yes, you know of an issue, and you'll disclose what that issue is. So that's basically the easiest part. However, in the event during this transaction, if you find out anything that is different from what you filled out on the property disclosure statement, this paragraph also advises you that you are to go in and correct that statement of any material changes, and then we have to let everyone know that is currently inquiring on the property or anyone that's under contract for the property. And then by not doing so, you could be exposing yourself to liability from non-disclosure to your buyers. A lot of this is talked about in here. In agreement, in addition to that, you could also be exposed to my commission, right? This is one of the things when people talk about default. This is one of the things they don't understand is default is not just default to the buyer and seller. If you default as a seller, you're not only defaulting to the buyer, but you could be defaulting in the listing agreement as well to your agent, as well as, which then possibly could be going to the other agent. But this is basically saying be honest on your property disclosure. And in the event anything about the property disclosure changes during the listing period, that you need to go in and change it. And we update everyone that has seen it. Okay.
Joseph, can I ask a quick question about that?
Sure.
Because in Ignite today, we were talking a little bit about disclosure. And, I know some people have always said, well, if I don't know about it, I can't disclose it, which I don't feel like that's appropriate at all. But the thing that came up was the fact that how far to go back on your disclosure. So like, if you have something that happened 5, even 10 years ago on a property that you've owned for 20 years ago, but it's been fixed and not an issue since then, say maybe a major thing with the air conditioning unit or something like that, does that actually have to be disclosed? Or they were saying that every market center is a little bit different. So I just wonder what your take is on that, is how far back do we try to get them to disclose?
So for that specific example, if they replace the air conditioning, they should disclose they did replace the air conditioning, right? Just put that in there. I don't know that I would put any sort of timeline on it, because they're either going to find out now or they're going to find out later. And a lot of people are really hesitant to say, well, if something was done and it was fixed, I don't want to red flag anyone. Well, possibly, and I understand that. However, if something was done, it was fixed, even if it were fixed properly, then there shouldn't be any reason to disclose it. Because if they, I'll give an example. A couple of years ago, we had a property listed, and the seller had lived in the house for plenty of time. And right after they moved in, they had an issue with a leak in the kitchen. Pretty big issue. Fast forward almost 15 years, I think. I can't remember how much it was. Seller filled out the property disclosure, totally forgot about it. He just absolutely totally forgot about it. There was no malicious intent, which, by the way, is also part of this. This document of, you know, forgetfulness is not an excuse, but it's also can keep it from being some sort of like malicious intent. The buyer found out, freaked out, absolutely thought that it was, you know, something that they were trying to hide. We had full proof that it wasn't. It was just, well, I get proof that the seller's word. And finally, it came down to the buyer to say, listen, had you known about this, would you not have moved forward on the house? And they said, well, yeah, we would have, because we've got a contractor that looked at it and said everything was fixed properly. I'm like, okay, well, then that's the issue, right? Like we'll reimburse you for the contractor just to make you feel better. But at the end of the day, it's they're gonna find out at one point or another. And what you don't want to happen is them find out and have it look like in any situation where you've covered it up. So, you know, from an AC 5 years ago, if it were fixed or work was done on it, I mean, if it's a AC was, you know, had a freon leak and was fixed, I don't know that I would naturally consider that an AC issue. That being said, I'm also not going to be the agent, nor should you, that's going to give your seller advice is specifically what they disclose. So if a seller comes to you and says, well, I had this work done on the AC, should I disclose it? Say, well, if you know about it, then I don't think it's a terrible thing to disclose. But that's also based on your interpretation, Mr. Seller, of this document. You know, on the flip side, that's why in your buyer consultations, you should always prepare your buyers to say, listen, the property disclosure is nothing more than a 4-page disclosure on a piece of paper that's filled out to the best of the knowledge of the seller, that's filling it out while they're also signing 28 different pages of documents and everything to get their home on the market, getting their house ready, planning on a move, and doing all that. So just understand where they filled this out. We're going to verify all this. Now, where I would say to keep, you know, one of the things on the property disclosure that I have seen get people in trouble lately, and you want to have this conversation with your seller, is say, if you don't know, then don't guess. Truly say you don't know. For instance, if you don't know what type of piping is in your home, then do not say it's a certain type of pipe unless you know it's that type of piping. We've had a handful of them recently where they've put PVC or they've put no representation, which again, if they don't know, but they put PVC and it came up as polybutylene. I mean, honestly, my personal opinion on polybutylene right now is if there hadn't been a problem, it ain't gonna be a problem. But there are some people who, you know, think polybutylene is the worst thing that's ever been invented and freak out. And if they were disclosed incorrectly on there, then yeah, then the seller's open for liability. If you didn't know, then why'd you put PVC? But as far as how far back, if they remember it, it needs to be disclosed. Okay.
Can I ask one question about that polybutylene piping?
Sure.
Just because we came from Virginia and a lot of the older homes up there were made with that, but some places won't like cover you insurance wise. Is that an issue down here in South Carolina?
It would be specific to the insurance carriers. I have not seen an issue from an insurance standpoint for polybutylene specifically. Like if I remember correctly, I think we have it in our house that we bought in Brickyard. Like a lot of the homes, especially a lot of the Wheeling homes that were built in the 90s, they all had it. Right. And it's not just the polybutylene part. That's just the part that was the easy fix when they fixed it all. It's actually the polybutylene combined with the certain connections. So again, by the way, just to be very clear, that's my personal opinion. If you are a client, I would say, well, my experience on my house is this. Let's give a call to your inspector to get their opinion on what the concern level should be on this. Okay. All right. Paragraph 10 basically says that the owner authorizes me to disclose information about the property to agents, subagents, prospective buyers, and all inquiring parties. It will be in accordance to the broker's company policy. So material facts, which will be facts that are going to be on the disclosure, will be disclosed. That's actually done by posting the seller's disclosure in the MLS. Okay. Taxes. Basically, it's saying that taxes will be prorated and you're going to be responsible for the taxes that are due from you for the time that you lived in the home. Coastal Tidelands and Wetlands Act, in the event the property is affected by the provisions of this, an addendum will be attached to the sales agreement incorporating the required disclosure. Obviously, if that's going to apply to the property that you have, if an addendum is required, they just need to know that they may have to fill that out. All right, paragraph 13, everyone's favorite. clear cooperation policy and how we try to get around it. All right, so multiple listing service, public marketing. There are two options. I'm going to go with the second one first because it's the easiest. Option 2 is the seller does not consent for their property to be placed in the multiple listing service, and they wish to have their property listed as a brokerage exclusive. This prohibits the seller and broker from conducting any public marketing, which includes but is not limited to signage, social media, and any communication, oral, written, or electronic, that can be disseminated to the general public of the property, and will restrict the marketing of the property only to the members of the broker's firm. Broker and owner agree to comply with any paperwork required by the multiple listing service, which the brokers remember and verify the property will not be publicly marketed. There is no planet where this could be an option. Because what this is saying is, Mr. and Mrs. Seller, we're going to put your home for sale and you can't tell anybody except me and agents in my office. Now, the purpose of this was for people that wanted to have what's called a broker exclusive, where it's only going to be listed to or shared with people within the firm. A lot of people think that this is the option that you choose because you want to delay or you don't want it to go in the MLS and you want to use it as coming soon. That's not the case. This is simply what it is. It's a broker exclusive. No one will be made aware of the property except for the members of the brokerage that have the listing. Okay. Then there's option 1, which 99.9% of the planet should be using on this one. And this is that the property shall be entered in the multiple listing service of which the broker is a member within the time frame stipulated by their bylaws, rules, and regulations. I'm going to read all of this and I'm going to come back and translate it. This shall constitute an offer of cooperating brokerage to all members of the listing service. Owner agrees the broker may compensate an agent representing the buyer from the fee described on page 3. Owner agrees or does not agree that the listing will be placed in electronic marketing mediums, including but not limited to the internet, MLS, Internet Data Exchange, or an IDX, or other similar online computer services, and to share listing data, including the property address, with other members of the MLS for marketing and advertising purposes only. Owner further agrees to permit other real estate firms who belong to the listing service of which the broker is a member to advertise the listing on the internet in accordance with the listing service's rules and regulations. Very important. That's why it's in bold. Broker and owner agree to abide by all rules and regulations of the multiple listing service on which the property is listed. Okay, so what this means is you're going to put the property into the MLS based on the time frame stipulated by our bylaws. The time frame stipulated by our bylaws is it does not have to go into the MLS with any period of time based on this document. However, the moment you publicly market it, we have to follow the clear cooperation rule, which means it has to be in the MLS within 24 hours or 1 business day, I think is what it is. Okay. So if you're going to take a listing that's not going to quite, you don't want to go in the MLS because they have to get the house ready or that sort of thing, and you have this document signed, that's fine, but they technically cannot tell anybody. Even if you post date it or whatever it may be. Now, some would argue if you post date it, it's not a valid listing agreement until the post dating. I think you're getting into semantics on that and getting in a little risk area. But as long as you have a valid listing agreement, the moment it's talked about or advertised publicly, then you have to have it in the MLS within 1 business day. Now, let's just say, for example, I list Christine's house and it's not going on the market for 2 weeks. That's fine. I can help her. I can help her with scheduling contractors, whatever it may be, giving her recommendations, walking her through the process. I can do all of that and not put it in the MLS until somebody says something about it publicly. I can tell my brokerage about it. I can tell people within my office about it, but I can't tell anybody else. The moment I do, then it has to go in the MLS. If that's the case, you can put it in the MLS, but then not show it. The MLS has also removed its guidelines for how long you can have a home available in MLS, but not available for showing. So that's another quote unquote workaround. Questions about this?
I had one. Does
Okay.
that apply to the seller as well, that they can't promote that their house is coming soon, or is that just us as an agent and an agency?
So as this is written, it does pertain to them as well, because it's saying they will also abide by the rules. By signing this and agreeing to this, they also abide by the rules. And this is becoming an issue, and I'm not saying it's a perfect one. I mean, we're having this all the time where, or not all the time, we've had it a couple of times where the sellers haven't put their home on the market yet. They put it on their neighborhood Facebook page and happens to be occupied by another real estate agent in there who felt it was the highest and best use of their time to then go say, hey, to the MLS, look, they're advertising this publicly. And then what typically happens in that is we get a warning that says, hey, we were just made aware of this, so you have 1 day to get in the MLS. Or terminate the listing agreement. Now, if you have a situation where, let's go back to the Christine situation. Christine and I have met. She's a past client. We've worked a handful of times before. I know I've got the listing, and we're going to sign the listing agreement on November 1, and in the meantime, she's going to do stuff to get the house ready. Well, I don't have a listing agreement at that point. So the question becomes is, can you talk about it publicly at that point? Well, I guess you could. You could say, I know of a house that's coming available in Brickyard. The problem is license law says you can't, as a real estate agent, advertise property without a listing agreement. So this is another area people try to skirt it and say, well, I don't technically have the agreement yet. Okay, that's fine, but you're also limited on how much you can advertise it, because by law, you have to have an agreement to advertise it. Isn't this fun? All right, any other questions about that? Let me see if there's anything thrown in the chat box. All right, page, whatever page we're on. Page 4, lockbox. This is where the owner agrees or does not agree to have the MLS lockbox put on there. This is also the disclosure of the risks of having a lockbox. In the event you have a tenant in the property or someone other than the owner that's signing the agreement, you would need to get, or you would want to get, a lockbox addendum and have that signed by the tenant and or occupant in the home that's not on this agreement. The reason for that is it just discloses, hey, we're going to regulate who comes in your house. They have to be a member in good standing, yada, yada, yada. However, you will have people going through your house. There is a risk, and you're not going to hold us liable for loss of personal property, et cetera. Paragraph 15 states that it is the owner understands that it is my responsibility to present offers to purchase to the owner for your consideration, terminates at the closing. So if you get more offers on there, I don't have to continue to present them to you, or if it's expired. Now, if you have an expired contract, you get an offer on it. You'd probably want to present it to your owner, but maybe get something in writing that they'll protect you. Marketing of the property after accepted offers. Brokers shall not continue marketing the property after the offer has been accepted unless requested in writing by the owner to do so. This is kind of a weird one because it still defaults to this. This does not mean that if the buyer puts something in writing that, or excuse me, the seller puts a request in writing, that you don't have to mark it as active contingent. The rules specifically state you have to mark it active contingent if you have an offer on there. You cannot get around this. We've had, very interestingly enough, very recently, with one of our lovely members on the call today, where they had represented a buyer that went under contract for a property, and the seller wanted it to stay active in the MLS, which I get. I totally get it. I mean, I understand that. And the agent basically said, here's an addendum that says we're going to keep it active. You can have that addendum signed all day long. It does not negate, you can't sign an agreement that basically says you can now go break the MLS rules. Okay, it has to go to active contingent. Now, yes, is there an argument that if they've got a home sale contingency that, you know, they still want to get exposure on their house? Of course there is. So get involved in the MLS and let's change it and have a different status that says active with home sale contingency, right? Instead of just active contingent. Paragraph 17 basically says that there's no set commission rates or fees, that they're negotiable. Paragraph 18, basically this is your agreement, Mr. Owner, to maintain the property, including the lawn, shrubbery, and grounds until the day of closing or possession, whichever occurs first. You also warrant that all heating, air conditioning, electrical, and plumbing system, as well as built-in and appurtenant equipment or appliances, shall be in operative condition on the day of closing or possession, whichever comes first. So if they if they have things that are not currently operating, you need to know that ahead of time so you can disclose it, because this agreement says that if they'd have all of these in operating condition. Paragraph 19 says, when a buyer is found for the sale of the property, the owner shall enter into a written sales agreement, which will contain the terms of the sale, and you have to follow through. So basically, Mr. Seller, this paragraph says if you agree to sell, you have to sell. Lead-based paint, in the event your home is built prior to 1978, that you will be required to fill out lead-based paint disclosure, which is basically a do you know anything about lead-based paint? You'll fill that out. Mediation clause, if we do have a dispute arising out this agreement, this isn't your purchase and sale, this is your listing agreement. So Mr. and Mrs. Seller, if you and I are to get into a disagreement, we agree to pursue mediation first before we go into suing each other or anything like that. Paragraph 22 says, I will not discriminate on who I sell your home to, or to whom I sell your home. Paragraph 23 still just, they're hanging on by a thread, but you can still use faxes as part of your communication with this. So if you fax over a signed piece of paper, it's enforceable. Paragraph 24, parties agree that the broker may take action to enforce this agreement. Basically says it's an enforceable agreement. So if I perform on it, I get you something and you get an offer and you default on it, this is enforceable. Sex offender or criminal activities or information, it is not my obligation to disclose this or to go find this out. So if any parties do come in and ask me questions about it, I'm just going to point them into the direction of the sex offender registry or local websites, and as it relates to sex offender and criminal information. Photography, seller conveys any and all of the seller's audio, photography, and videography rights in perpetuity involving the seller and seller's family, seller's property to broker for marketing and advertising and any and other purpose deemed necessary by the broker. We are, for some reason, having we've had some sellers that have come back after a closing or after a listing is expired and said, remove all pictures from Zillow. You can remove it from the MLS, but it's still going to be out there. So you just need to explain to them that, we'll get as much off as we can in the MLS and do that. But, by signing this, you've agreed that it's going to go out there. That's part of marketing your home. Paragraph 27 says, should you want to survey or surveil your property while it's being shown, you have to abide by South Carolina law. And you can either agree or you can either let me or not let me disclose potential surveillance as the broker as I'm deemed necessary. Now, if you get into this discussion, it's important that you let them know if they don't want it disclosed, because it's really disclosed potential surveillance. By signing a buyer's brokerage agreement, there is a disclosure in there of potential surveillance. So where they may not want you to disclose it, you need to let them know, hey, if you are going to have surveillance done on the property, buyers will more than likely know that there's a risk of that or a potential for that based on the agreement they've signed. Other terms and conditions, again, this is where you could put a stipulation if you are having a graduated listing agreement, or if you're having a marketing fee or anything you can have that added to here. A lot of people put in here an easy termination in the event that, either party is unhappy with the services, they can terminate, or unhappy with the situation, they can terminate the services. And then the last bold one basically says that the people signing actually have the ability to sign. And that's a legally binding agreement. And by signing it means that they are going into an agreement. And if they have any questions or need any notices, they'll receive communications at the email address and phone listed below. And that is the listing agreement. What questions do you have? I'm going to go pull up a couple agreements that we talked about before, but while I'm doing that, what questions can I answer?
So I'm going to go on a listing appointment, not this Friday, but next Friday.
Okay.
They're not moving until June.
Okay.
And we've already been chatting back and forth. I don't feel like they're going to go with somebody else, but I guess my question is should I go ahead and get it signed or not really?
So my answer is always go ahead and get it signed, because you want to have it signed. The risk of having it signed, and let's say you have it signed and it's not going to go in the MLS until June. First of all, that's a very long time.
Yeah.
And technically during that, they're not allowed to tell anybody about it or publicly market it.
Okay.
So you're going to have to use your judgment on how much you trust not having it signed. If Now, you can also
Can
say,
you-
here's what the rules say, Mr. Seller. You know, we can have this signed and post dated to then. Technically, what the rules say here is that, you know, we won't publicly market it until it's ready to go into the MLS. So if we need to change the terms of this, we can, but in the meantime, we're not going to start marketing the property until you're ready to list it.
I have a question. So that's 6 months away, that listing potentially.
Right.
Can you have them sign an agency disclosure with you and date it for 6 months? Will that keep them as like you're their agent
It won't.
and not
'Cause
signing
it's-
the list?
No, it's simply a disclosure at that point, and you're not in an agency agreement with them.
So let's say you do an agency agreement with them, like a 6 month, would that hold them with you and not sign the listing agreement? I'm just trying to, so it's
The
not
agency
like,
disclosure is just a disclosure, so that's not a binding. There's nothing binding about that. So if they sign
But
that, all it is saying that they understand what the different types of agency are.
yeah, I meant to say agency agreement.
So you're saying they sign an agency. What type of agency agreement then?
Just that, you know, you're going to work with me, Keller Williams, versus the listing agreement.
Well, there wouldn't be an agency agreement that would be just a blanket, like a general agency. It would have to be either specific to represent as a buyer or represent as a seller for the house. And then that would be a listing agreement.
Got you. Okay.
Yep.
I got it. Thanks.
No problem. I'm not looking for this one other.
Joseph, I had a question about surveillance.
Okay.
Because so many people have like the Ring camera or the Ring doorbell or different things like that, which do pick up, you know, sound.
Right.
So my question is when we're, you know, talking with a client, showing with a house, and you say that surveillance stuff, so they don't have to turn that off necessarily. And if so, when we're talking with a client, we should probably be really careful about negotiating or discussing things even in the house or even on the property of the house. Is that correct?
Correct. Yeah, I mean, that's kind of a thing that's been coming up a lot now as people go out to the front porch, and they start talking. And what that basically does is the seller's listening into what they're saying, or could be listening into what they're saying. So yeah, you would want to be careful to say, hey, let's hold off on any conversations about this until we get, you know, get back to the car or whatever it may be.
Get outside. Yeah, get outside.
Okay. Yeah, but it's even not outside because I know we ourselves have a Ring flood cam that picks up everything that I tell it to within the range.
Right.
And video. So even if you're standing on the front porch, which I know when we bought this house, we stood on the front porch and negotiated with our, you know, talked with our agent about what our plan might be.
Mm-hmm.
So if they had something that we weren't aware of, they would have picked up on all of that.
Correct. That is correct. So just be very, very careful on that one. All right, so what I wanted to look at really quickly, I'm going to go back in here because we talked about them earlier, are these rejection of offer forms. So there are two forms that you have in a situation where your buyer, if your seller is not going to continue negotiating with the buyer. First one is form 315, which is a simple rejection of offer real estate or offer rejection form. This is a South Carolina or LLR form, and this is really just signed by you. This is required. So in any situation, if you have a listing, if you get an offer on it, anytime that they're going to stop negotiating, this is required for you to send to them as a rejection of offer. It's only signed by you, by the firm. It's not required to be signed by the seller. Okay, so it's basically saying we're not counter offering anymore. Then there's another one, that's form 314, and then there's the other one that's form 312, and this is the rejection of a counter offer and solicitation of a new offer. So this is what you would use in a situation where you would have multiple offer situations. This is signed by the seller as well as you. So it basically says at the time of signing, the seller anticipates or does not anticipate or makes no representation of the possibility of competing offers. If you don't have competing offers and you're just terminating the agreement, then you can just have the other form signed, or you're terminating negotiations. If you do have multiple offers, then I would have this one, that would come back and say, hey, bring your highest and best. Sound good? Let's see. Question. Anything post dated and not binding until the date on the contract. Is that correct? So, well, it depends on anything. It depends on, I guess, specifically what you're asking on that one, Regina. What do you mean by the question?
Let me unmute. So what I'm asking is if she went and got a listing agreement and post dated it till June, which is when they want to put on the market, technically that is not a binding agreement until the date on the contract. Isn't that correct? So it
I don't-
doesn't. I mean, I know post dated checks are a big no-no these days because obviously people can clean their account out and then the check is no good. So I'm just wondering if a contract has a date on it, isn't that the date that the contract is binding?
Well, I don't want to get too caught up in whether or not it's a bind. So there's two ways to look at it. Okay, let's say if it's not a binding agreement, then you can't talk about the property because you can't advertise the property you don't have an agreement on, a listing agreement on. So there's that. So if that's the route that you're going, then that, you could say, but you're protected up until that day, because they'll still be bound to it. But I wouldn't, as far as using that as a way to have the listing and then be able to talk about it, I don't know that you'd be covered. Now, if you want to have it post dated and saying that it's not going to be listed until June 1, sure. And you're not bound to anything in that. You could argue that, yes. However, it's not going to work as a workaround to be able to do a coming soon.
No, I'm really using it in regards to if the people suddenly changed their mind in March
Oh, yeah.
and she had a contract, they could go ahead and sign another listing agreement.
They could. They'd just be at the
and
risk of having
we-
two starting June 1.
Right.
So that would be, it
That's
would,
interesting.
yeah.
They would have to notify her that they weren't gonna no longer be using her. Okay, that makes sense. Thank
Yep. All right. Anything else? Any other questions on the listing side?
Joseph,
Yes.
did you say the forms 312 and 314, they're required, both of them?
Not both of them. 314 is required.
Okay,
Rejection of offer form, yeah.
Thank you.
314 is required according to LLR.
thanks.
Yep. All right. Anything else?
Yeah, just to clarify, so I should put Friday's date as the start date after I have a discussion with them and find out if they can keep quiet about their selling their home.
Yeah. And then if not, then you can post date it like Regina suggested, or, just keep a dialogue going in the meantime.
Yeah, yeah. Okay, all right.
All right. Well, guys, if you have any other questions, shoot me an email or give me a call. Otherwise, I will see you next week at 2, where we'll dive back into the purchase and sale agreement and all the fun that's been happening with that in the last month.
Thank you.
All right. Bye, everyone. Thanks for being here.